The first matter to come before the court this morning is State of Ohio versus Tina D'Agostino. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant, wish to reserve that time, let me know when you get started. I'm keeping the clock and I can keep you apprised of the passage of time. We've read the briefs and we're ready to see who you are.
Thank you. Attorney Matthew Nebraska here on behalf of Mike Duff for the defendant appellant, Tina D'Agostino. Ms. D'Agostino was convicted of unauthorized use of a motor vehicle, felonious assault with a firearm specification, and domestic violence, and was sentenced on October 9, 2012. Direct appeal was had in this case, and many of the matters at issue in her petition for post-conviction relief were also addressed in that direct appeal, though not all. She then filed, obviously she filed a petition for post-conviction relief pursuant to revised code section 295321, and she argued ineffective assistance of counsel. The trial court denied the petition without a hearing, finding that she failed to state sufficient grounds that her trial counsel, Attorney Berkey, was impaired due to illness. It was also found that the allegations of a lack of proper preparation on the part of Attorney Berkey, particularly in regards to the preparation with her ex-witness at trial, when Dr. Eisenberg failed to show that further preparation of trial tactics or different tactics would have led to a different probability of success at trial. This led the trial court to conclude that no prejudice was shown, and the trial court also ruled that the other two allegations against Attorney Berkey were barred by res judicata based on the decision of this court of direct appeal. Obviously, where a petition for post-conviction relief is made, there has to raise an issue that the petitioner's conviction would be void or avoidable based on constitutional grounds, and that the claim depends upon factual allegations that cannot be determined by examination of files and records of the case. The petition must state a substantive ground for relief, and if that is the case, it requires a hearing. Obviously, appellate courts review this decision based on an abuse of discretion standard. I will note, obviously, that a hearing is not required if the affidavits do not warrant it based on the trial court's evaluation thereof.
So what are the factual allegations that give rise to the need for a hearing that were not before the court in the direct appeal?
The primary issue that the appellant has identified is based upon the affidavit of Dr. James Eisenberg, who was the expert witness at trial. Much of his testimony was addressed in the direct appeal. However, the issue that we believe is indicative of the reason and the need for the hearing is that he brings up the fact that the trial preparation of Attorney Berkey led to, and actually the lack of interaction between he and Attorney Berkey showed that she wasn't prepared. She didn't know how, in his belief, that she didn't know how to properly question an expert witness, she didn't know how to question particularly a forensic psychologist, and that in so doing, she opened up avenues of attack on the part of the prosecution, which they were able to take, and it also subsumed what he thought was an important part of his trial testimony. Yes, his primary issue was talking about battered women's syndrome, but he believed that an important part of his findings was the fact that this was actually very simply also a self-defense issue. In doing so, he thought that Attorney Berkey failed on numerous occasions to get in contact with him. His only real interaction with her prior to trial, other than a simple phone call to set up the report, was on the day of the trial when they sat down, they had lunch, and she just talked very briefly. It's the position of the appellant that this is indicative of a general lack of trial preparation. It creates issues that require at least a hearing to develop. Obviously, Attorney Berkey herself is not going to submit an affidavit saying that I was ineffective, that I was unprepared. And that's why we believe that at least an evidentiary hearing to at least address those issues is necessary. She also submitted several other affidavits of certain family members and friends who were present at trial. Again, obviously, they're not trained attorneys, they're not professional witnesses, their affidavits are not as noteworthy, but they do go back to the fact that the overall feeling of the appellant and her family and her own expert witness was that Attorney Berkey was not prepared and there were extenuating circumstances. We're very much aware of that, and we're very much aware that in the case of when you assert ineffective assistance of counsel based on attorney illness, you have to point to specific issues that require, that show that there was a probability of success but for. And we firmly believe that issue is shown by Dr. Eisenberg's testimony, in that her theory of the case we feel was somewhat muddled, could be much more clear, and could have gone to issues that would have improved Ms. D'Agostino's chance of success in trial. Ultimately, we realized that the trial court has its discretion to evaluate the affidavits, that they can take it for what they're worth. And this court also has addressed many of the issues in regards to Dr. Eisenberg. However, the issue of overall trial preparation, overall conduct of trial and theory of the case is something that is outside the record. It's something that at least requires further discussion at an evidentiary hearing. We're not saying that, obviously, that we believe, we do believe that we would be successful, but we're not saying that it is necessarily followed from a hearing, but we believe that at least a hearing will be necessary to develop these issues. That's all I have.
Please, the court, my name is Natasha Guerreri, and I represent the county of the state of Ohio in this matter. I think it's important to note that with regard to the ineffective assistance of counsel, that in regards to post-conviction relief petition, that defendant has to show not only that the attorney was incompetent based upon facts outside of the record, but also that there was some sort of resulting prejudice as a result of that incompetence. And here, looking at the affidavits that Ms. D'Agostino did present to the court, just in relation to the family members, there were 5 family members, and that presented affidavits, and those addressed issues that they felt that showed that Attorney Berkey was ineffective in some way about not objecting as much as they thought she should have, her appearance, but those issues, but those affidavits did not present any sort of reasoning as to how that prejudiced Ms. D'Agostino. The issue of her medical complications was addressed in her prior appeal, that this court did issue a decision on, and the court noted that. And also, there was no allegations as to what particular objections needed to be made, that she should have made, that caused any sort of prejudice in that way. And in looking in Dr. Eisenberg's affidavit, there was also that lack of prejudice that was present in the affidavit. There, as the trial court noted in its decision denying the post-conviction relief petition without a hearing, that Dr. Eisenberg's testimony mirrored that which was contained within his report. there was no allegation that there was any sort of additional testimony that he was going to provide. Also, that there was no allegation that somehow the trial would have been different had there been different questioning or additional preparation. So that's an important lacking element that the trial court took note of when it decided to deny the petition without a hearing. And in reviewing an ineffective assistance claim, this court can go straight to the prejudice element and determine whether or not there was ineffective assistance of counsel just based upon the fact of lack of prejudice. And the affidavits here do not provide any sort of prejudice element that is required for her to prevail upon an ineffective assistance of counsel claim. Therefore, the state would argue that the trial court was absolutely correct and did not abuse its discretion in denying Ms. D'Agostino's petition for post-conviction relief without a hearing because the affidavits that were presented did not support an ineffective assistance of counsel claim. Not only for lack of prejudice, but the showing of incompetence of Attorney Berkey. I guess if there are no questions for me, I really don't have any further arguments to make at this point. Thank you, Your Honors.
Thank you both for your presentations this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides as well as posted on the Ohio Supreme Court website. Thank you.